Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
The Fifth Circuit has ruled that the National Labor Relations Board's structure likely violates the Constitution by shielding board members and administrative law judges from presidential removal. The decision freezes several unfair labor practice cases and opens the door to broader challenges against independent agencies with similar protections. Here to help us understand the implications for workers and employers is Senior Fellow at the Century Foundation and former Chairman of the National Labor Relations Board, Lauren McFerrin. Ms. McFerrin, thank you so much for joining me.
My pleasure.
There are some really important legal news topics surrounding the National Labor Relations Board, but before we dive into the specifics of the news, let me ask you to kind of re-baseline us on how the NLRB is structured and how its administrative law judges work.
Absolutely. So the National Labor Relations Board has the very important job of enforcing workers' right to act collectively, whether that is to join together and complain about unfair working conditions or to form a union and bargain collectively. The unique thing about the National Labor Relations Board is it's kind of the only game in town you can go to enforce these rights. You have to go to the agency if you think your rights under the National Labor Relations Act have been violated, and only the agency can prosecute your case. Now, the way a prosecution works is the General Counsel's office, which is represented by a number of regional offices across the country, will look at your case, decide if it thinks your rights have been violated, and if the General Counsel decides to proceed, the General Counsel will prosecute your case. And the first step of that is always to try to settle the case. But if they can't settle the case, then they will try the case before an administrative law judge. If either party, either the General Counsel or the respondent, who is usually but not always an employer, is unhappy with what the administrative law judge rules, then they can appeal that decision to the National Labor Relations Board. The National Labor Relations Board is a 5-member body, though it is down to only 1 member right now. It is normally a 5-member body that would then adjudicate those cases and decide whether the administrative law judge got the answer right or got the answer wrong.
Now let's dig into this recent case. The Fifth Circuit decided in what, at least as I've read, is called the SpaceX case, so you can fill in the details there, that the structure of the NLRB itself was unconstitutional. So help us understand what the issues are that are raised in this case and what impact this decision may have.
The 2 issues raised in the case were, first, whether the agency's administrative law judges, and second, whether the board members themselves are unconstitutionally protected from removal. And what I mean by that is both of these adjudicators, both the administrative law judges and the board members, have protections by law. The administrative law judges are protected from removal. They can only be removed for cause, and that determination has to be made by the Merit Systems Protections Board. And similarly for the board members, the president can only fire them for cause. That's in the National Labor Relations Act, that you can only remove a board member for malfeasance or neglect of duty. Now, the allegation is that these removal protections that both of these bodies of judges enjoy is unconstitutional because it violates the separation of powers. It is an unconstitutional intrusion by Congress into the executive branch's authority to manage executive matters. That Congress, by saying these people can only be removed for cause, unconstitutionally tied the hands of the president to manage the executive branch. The Fifth Circuit found not only that that was true for both the administrative law judges and the board members, and the Fifth Circuit was the first circuit court to find that for board members particularly, or they were likely to succeed in that challenge. But the Fifth Circuit also said that because the employer, SpaceX in that case, was likely to succeed in that challenge, that the court could act appropriately in stepping in and stopping the prosecution in its tracks. So ultimately, the question of whether people are properly or improperly protected from removal will be addressed by the Supreme Court. But what the Fifth Circuit has done, which is a huge blow to the agency, said any employer who can go to a court in the Fifth Circuit Court of Appeals And the Fifth Circuit will stop the agency in its tracks and prevent it from prosecuting any of these cases.
That's quite a divergence from precedent, isn't it?
Until this point, it had been pretty well understood that at least board member removal protections were legitimate under a Supreme Court decision called Humphrey's Executor. In about the last 5 years or so, there had been some developments in the law where some courts, including the Fifth Circuit, had raised the question of the removability of administrative law judges. So I'd say it's certainly an area where there's been a lot of legal activity lately, but the Fifth Circuit really went farther than any other court had done in not only saying these people are likely to succeed on their claim that the agency's judges are unconstitutionally protected from removal, but also that is such a harm to these employers that the agency can't even prosecute cases in the meantime.
I'm speaking with Lauren McFerrin. She's Senior Fellow at the Century Foundation and a former chair of the National Labor Relations Board. So let's take this decision now and talk about what it means. There are a number of efforts from the Trump administration to remove folks. We've heard it at the Fed, we've heard it at the NLRB, we've heard it in other organizations where we thought that those positions were protected from that kind of engagement. What does this mean, or what does this portend for the operation of independent agencies across the government?
It's a very concerning development. Independent agencies were created for a specific and very important purpose, which is sometimes you want to have decision makers, even decision makers within the executive branch, that will make decisions based on the long-term public interest rather than short-term political considerations. The biggest example that you'd see of this, of course, is the Fed. You want the Fed to be making interest rate decisions based on what is in the long-term benefit of the economy, not because the president needs a quick political boost. Similarly, for the National Labor Relations Board, you want an agency that functions like a court, an agency that functions like a judge there, to be making decisions based on the facts of the case and the precedents that they should apply to the issues involved. You don't want them saying, we can't pursue this prosecution because we'll get in trouble with the president if this company is a big political donor, or we're not going to certify the union that the employees chose at this business because that business is a close ally of the president or something like that. That denies due process to the parties involved and really fundamentally undermines the independent nature of this agency, which is very, very dangerous for what Congress wanted to achieve with creating independent agencies.
Well, speaking of Congress, I mean, they're the organization that creates independent agencies in statute. What are you hearing in terms of their response to the legal arguments that are being put forward now?
I think a lot of people, and probably people in Congress as well, are kind of waiting to see how this plays out through the Supreme Court. The Supreme Court has pretty strongly signaled that it is going to potentially allow the president to remove at least some types of independent agency leaders. It's unclear how far they're going to go. I think there are ways that Congress could step in and try to protect these agencies from, to use kind of other levers of independence, whether that's independent funding streams or things like that, to try to bring a little less presidential control. But I think the specifics of what you would want to do to respond are going to depend on exactly what the Supreme Court does. If the Supreme Court, for example, tries to carve out the Fed or tries to carve out agencies that act as courts, then the response will depend on exactly what the Supreme Court does.
And in the short run, what is the implication of the Fifth Circuit's decision on the day-to-day operations of the NLRB?
Unfortunately, not good. The NLRB was already really compromised because the Supreme Court has said that the National Labor Relations Board has to have 3 members in order to issue decisions. Because President Trump unlawfully fired one of the board members shortly after his inauguration, that brought the agency down to 2 members. So it doesn't have a quorum. It's actually now down to 1 member because one of the members' terms is expired. So we only have 1 person sitting at the NLRB. They can't issue decisions. But until this point, the agency has still been able to continue prosecuting cases, trying to settle those cases, moving forward with cases that would only then get stuck when they got to the stage of the board. Unfortunately, what this decision does, as I mentioned, is it allows people who, particularly very powerful or very resourced actors like SpaceX, Amazon, large national companies that have a presence anywhere in Texas, Louisiana, or Mississippi, the three states that comprise the Fifth Circuit Court of Appeals. Any company that has a presence in one of those states, if they don't want the NLRB prosecuting them, can just run down to court and get an injunction. And that kind of, as I said, halts the agency's efforts to protect workers' rights in their tracks. So workers now can go to the agency and can file charges, but the agency is going to be pretty hamstrung in what it can do about that.
So what happens next? What should workers and employers be watching as, I assume, the case is appealed?
I think, obviously things will play out through the court system. In the meantime, of course, the NLRB regional offices are still open and operating. I would say that workers should still continue to go and file charges. But in the meantime, workers have voice and workers have power, and they can use a lot of different channels to use that voice and use that power, whether it's public pressure, whether it's protests. So obviously one mechanism that you can use to try to get your employer to listen to your concerns is filing a National Labor Relations Board charge. But you can also, have a strategy for protesting. You can also have a strategy for public relations. There's lots of different ways that employees can use their voice, particularly now at this very critical time in our country's journey. Employees should be using all available mechanisms to raise their voice and try to build their power.
I've been speaking with Lauren McFerrin, Senior Fellow at the Century Foundation and former Chair of the National Labor Relations Board. Thank you so much for adding some clarity for us on this really important issue.
My pleasure. It was great talking with you.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.